Hi, my name is Mark Amadeo, and I'm the principal of the Amadeo Law Firm. I'm glad you could join us today in this very first edition of the GovCon video blog. Now, today's vlog kicks off a multi-part series that's aimed at providing tips to technology companies that are involved in government contracting or that are considering entering the government marketplace. Now, last fall we posted a white paper that provides an overview of the federal government's rights to technology under the federal acquisition rules. And that white paper provides a good backdrop for the action items that we're going to discuss today and throughout the vlog series. So we're including a link to that white paper in the video description. In today's vlog, we're going to discuss three things that technology companies can do early on to prepare for government contracting. And these are three things that the companies can do while reviewing a solicitation or preparing a proposal or during contract negotiations. So the first thing that technology companies can do early on is take an inventory of pre-existing technology or so-called background IP that might be used or delivered to the government under the government contract. Now, the government by default acquires certain rights to technology that's used or delivered to it under a contract, but its most expansive rights are typically over technology that's first created under a government contract or first developed with government funds. So it's important for technology companies to be able to distinguish pre-existing technology that wasn't created with government funds or under a government contract. And this is not only for internal purposes, but also contractors need to be prepared very early on to put the government on notice of its limitations or limited rights over pre-existing technology through the use of markings to the extent that technology does get delivered to the government during a government contract. And we'll cover markings later on in this vlog series. Now, a technology inventory can include a number of things, such as when the technology was created, what funds were used to create the technology, what rights were previously asserted over that technology, whether any copyrights or patents apply, and if the technology was created under a prior government contract, what rights the government already has to it. The second thing that technology companies can do to prepare for a government contract is review the solicitation for any data and patent rights clauses that might be inserted into the contract. Now, data and patent rights clauses set out the government's rights and the contractor's rights to technology that's used or developed under a government contract. And these data and patent rights clauses are taken right out of the federal acquisition regulations. However, there are often alternative clauses that can be inserted into a contract depending on the circumstances. For example, under one set of circumstances, the government may insert a clause under which the government owns newly created technology while leaving to the contractor certain licensing rights over the use of that technology. In most circumstances, the government will insert a clause under which the contractor retains ownership over new technology that's created while leaving to the government licensing rights over its use. In any event, solicitations will often set out the particular clauses that are expected to be inserted into a contract. So it's important for contractors to review the solicitations to understand what their anticipated rights are going to be under a government contract. There are also a number of other reasons why contractors will want to review those solicitations and those anticipated clauses. So, for example, if a contractor believes it may need greater protection over technology than is afforded under the standard clauses, it will need to understand very early on in the process whether there's any room for negotiation over those protections, and it will need to begin those discussions with the agencies early on. Second, to the extent that the government has more limited rights over technology that's delivered or used under a government contract, as we said earlier, contractors typically will need to put the government on notice of these limited or restricted rights through the use of markings. And contractors will need to comply with these marking requirements very early on at the outset of contract performance. This leads me to the third thing that contractors can do early on to prepare for a government contract, and that is have a strategy for dealing with licensing issues. So, for example, with regard to pre-existing technology that might be used or delivered to the government under a government contract, contractors should have on file any necessary licenses from third parties that use or own that technology. And those licenses should acknowledge the government's rights over the technology if it's used or delivered to the government under a government contract. Now, contractors should also have a handle on any licensing fees or any royalties that will be passed along to the government during the government contract, because those licensing fees and those royalties will need to be disclosed. And also, those licensing fees and those royalties will have to be factored into the cost structure of the contract. So, to sum up, the three things that technology companies can do early on to prepare for a government contract are: number one, take a technology inventory; number two, review the solicitation for the data and patent rights clauses that are expected to be inserted into the contract; and number three, have a strategy for dealing with licensing issues. So we're glad you could join us in this very first edition of the GovCon video blog, and we hope you join us for future episodes.